In the previous lesson, what we did was take an introduction to legal positivism in a little bit more detail, exploring and examining the general context in which legal positivism begins to grow and gain in popularity. We talked about some of the historical developments of the common law as natural law. So one of the theories being that the common law had in it, and as part of it, fundamental principles which were transcendent, in a very similar way to how Plato used to argue, when he was alive, how Plato used to argue that things like beauty and justice were transcendent ideas. We also took a look at the work of Blackstone in a little bit of detail, focusing on the idea that, according to the common understanding of the common law as a natural law theory in the mid to late 1800s, the concept of a new principle of the common law was not one that was developed by lawyers or new theories and new ideas as applied to new facts. Rather, it was discovered by lawyers. There is no such thing as inventing new concepts within the common law according to these basic ideas. There is instead discovering new principles of the common law. We also talked about the fact that as natural law began to decline as a result of a number of different things, it wasn't one thing particularly. There was the impact of the Second World War on the one hand. There was also the sort of growing shift away from very religious and religion-oriented theories of both politics and of philosophy and also of law, with the sort of general secularization that came with the wave of the Enlightenment. We see the beginnings of a shift in the development of legal jurisprudence away from this concept that law is inherently tied to morality, and instead separating those two concepts, law and morality, which is what legal positivism essentially does. This is not to suggest, however, that there is not a single theory of legal positivism that doesn't take into account concepts of morality. There are, of course, ideas that link with morality, but that essentially, in rejecting natural law, the legal positivists understands that law is not inherently derived out of morality and is not inherently linked to morality. In this lesson, we're going to talk a little bit more about the traditional theory of legal positivism, focusing on the theories of Austinian positivism. We'll talk about Austinian positivism in this lesson. We'll talk about one of the major critiques to Austinian positivism, this being the idea of international law not being considered law, which is, of course, a theory that I certainly reject personally. So, as a general recap, legal positivism originates from some of the revolutionary works and some of the revolutionary theories of law from the works and from the likes of people such as John Austin and people like Jeremy Bentham. John Austin was a revolutionary in his development. He believed that you can develop a theory of law which was separate to that of morality. There was a separation between law and morality in this way. And within this Austinian framework, we can see that the concept of law is not derived out of morality. Instead, the concept of law is derived out of the sovereign. So what John Austin essentially does is he takes the view of law and morality and replaces morality with this idea of sovereignty, this idea of the sovereign within the concept of legal creation. And what this essentially does is, because the sovereign is a tangible thing, it's often, at least when we talk about monarchies, a person, or it could be a parliament, or it could be any other kind of legislature. This essentially taking away from ethereal concepts like morality and applying instead concepts like sovereignty, which are much more concrete. They actually represent a person or an institution. What we do is we get rid of this idea that there are transcendent sets of legal norms and principles. So, according to the Austinian positivists, there are no transcendent set of legal norms that exist in the same kind of way of a natural lawyer, and how a natural lawyer would understand the concepts of the development of law and the interrelationship between law and morality. So the Austinian positivist is revolutionary in this regard, rejecting the basic principles of law and morality as being inherently tied to each other, which maybe today is not too much of a controversial opinion, but at the time was relatively revolutionary. And so legal positivism is the rejection of basic principles of a priori logic. So what this essentially tells us is the same kind of a priori reasoning that natural law depends on to exist is rejected by the positivists and the Austinian positivists specifically. So a priori is an epistemic mode of understanding knowledge, essentially. So epistemology is the philosophy of knowledge and the ways in which we understand knowledge and how we derive knowledge and our justifications for believing certain actions and certain things. A priori knowledge or a priori reasoning is reasoning that requires no external empirical evidence. Okay, so you can understand something and you can derive conclusions about things a priori if you can do so using your own rationality, your own reasoning, your own logic. And then you have the almost the opposite, the polar opposite to a priori logic or a priori reasoning, which is a posteriori reasoning, which relies on external empirical evidence for things. Okay, so for example, a classic example is that I could say that all triangles have three sides. This is a statement, a proposition that is either true or false. I can conclude from my own a priori reasoning that this is true, because I know that a definition of a triangle is a shape with three sides. So to say that something is a shape with three sides and saying that that has three sides, which is what essentially the proposition is tautological. It is obviously true. It is a priori true. I don't have to go out and empirically measure every single triangle that exists in the universe to try and measure to conclude that they have three sides or not. That's not how I would come to that conclusion. I could do so from sitting in my room, and I can logically deduce that that is the case. That is an example of a priori logic or a priori reasoning. This kind of reasoning, this kind of understanding, is something that is relied upon within natural law. For people like John Austin, the most important thing about law is that it determines the condition of its own existence, okay, rather than requiring this a priori reasoning. It means, therefore, that there are no external factors upon which law relies on its own basic existence. Now, in concluding this part here, I want to just make it very clear that one of the major critiques of Austinian jurisprudence is its relationship with international law. Now, international law was not as prominent as it is today when Austin was writing, but you may come to the conclusion that if law is derived out of the sovereign, then what about law that has no sovereign? What about law that does not exist in relation to any kind of sovereign authority? International law is not derived out of sovereign authority. So by sovereign authority, we're talking about, for example, state sovereignty, the sovereignty of a state. That can be represented as a monarch, as a single individual, as a dynasty, or it could be represented as an institution, like a parliament or a legislature. And so international law doesn't exist in that same way. And so as a result of which, this is a problematic aspect of the Austinian positivist theory, should I say, not natural law theory, is that Austinian jurisprudence depends on the existence of a sovereign to create law. As a result of that, international law doesn't exist, or at least international law isn't law, according to the Austinian positivist, because there is no sovereign authority, there is no international sovereignty that exists. So as a result of which, how can an Austinian positivist conclude that international law is law? This is not to suggest that international law doesn't exist according to an Austinian positivist. That there is a collection of things that we can describe using the phrase international law, but according to an Austinian positivist or someone who believes in Austinian jurisprudence, this thing that we call international law, we can call it international law all we want, but it is not law in the same way as domestic legal systems develop law. Now, this is not even an uncontroversial opinion in some realms of academia, specifically within common law jurisdictions. There are lots of common lawyers who do not believe international law to be law, not necessarily because of this particular justification, but just generally because it is different to the domestic systems in terms of enforcement and in terms of the ability to apply said law. That's a general critique of international law, but this is quite interesting how an Austinian positivist, since an Austinian positivist will derive their understanding of where law comes from the sovereign. The concept of international law cannot exist as law in the same way according to this kind of positivism.